Hi everybody, thanks for coming back to the channel. We're talking about the missing few, as I call them. Aircrew, British and German, Polish, Czech, shot down during the Battle of Britain and unrecovered in 1940. So remained missing with no closure for families. How can this be in this country that this happened? Well, we've got a series of videos now. This is number 6. The first one explains the background to how all this has happened. Some of it is understandable, some of it isn't. And the rest is a chronology of the recoveries that have taken place, both by the authorities and by enthusiast aviation archaeologists. So, we've now got to the situation where on the 9th of September 1986, the Protection of Military Remains Act came into force. Now, what this essentially did was give the weight of law to the notes for guidance, the regulations that the Ministry of Defence tried to impose upon recovery groups, but any infraction of those, there was no penalty in law. At best, all the MOD were going to do was just withdraw cooperation. So if you went and recovered an aircraft without permission, there really wasn't a great deal that could happen to you if you found human remains or otherwise, provided you complied with the coroner's procedure, and in respect of any ordnance, you handed all of that into the police as well. So this is what's happening. And then Michael Mates MP, who was a retired army officer, got wrapped up with this, and it wasn't really specifically geared towards curtailing or restricting aviation archaeology. It was more to do with protecting shipwrecks, making them prohibited sites, war graves, so that they weren't going to be plundered by salvage people and so on and so forth. But then it was extended to aircraft crash sites, making them prohibited sites. So what I want to do in this video is look at the chapter 5 that I wrote in the old book, which really explains the Protection of Military Remains Act. And I do have some legal training. I was a police detective for a long time, so I've got a lot of experience looking at legal statutes and things. And I think that will help me interpret it. So what is an Act of Parliament? I mean, this might be a bit basic, but you know, let's go back to basics. So an Act of Parliament is enacted by the King's Most Excellent Majesty now, not the Queen's, or it was the Queen, God rest her soul, in 1986, by and with the advice and consent of the Lords Spiritual and Temporal, and the Commons, being the House of Lords and the House of Commons, in this present Parliament assembled, and by authority of same. So every act, every statute has what's called a preamble, which essentially is a paragraph explaining what it's all about. It's a bit like the introductory paragraph in an academic journal article, I suppose, similar kind of thing. So the Protection of Military Remains Act preamble says it's an act to secure the protection from unauthorised interference of the remains of military aircraft and vessels that have crashed, sunk or been stranded, and of associated human remains and for connected purposes. So here we have it. So in this context, an aircraft includes a hovercraft, a glider or a balloon, as well as the obvious powered aeroplane. And a controlled site means any area designated as such a site under Section 1. Remains in relation to part of an aircraft or vessel which has crashed, sunk or been stranded includes any cargo, munitions, apparel or personal effects which were on board the aircraft or vessel during its final flight or voyage, including the case of a vessel, any aircraft which were on board, and any human remains associated with the aircraft or vessel. So that's quite specific, isn't it? The Secretary of State may designate as a controlled site any area, whether in the United Kingdom, in United Kingdom waters or in international waters which appears to him to contain a place comprising the remains of or of a substantial part of an aircraft to which this act applies, or a vessel which has to be sunk or stranded. So, essentially, in terms of aircraft recoveries, it basically is about the United Kingdom. So, the Protection of Military Remains Act is a British Act of Parliament. It doesn't apply if you were operating in Europe. That's a whole different ball game, and we maybe talk about that one day. So, how big's a controlled site then? Well, the Act says it's an area designated as a controlled site shall not extend further around any place appearing to the Secretary of State to comprise remains of an aircraft or vessel which has crashed, sunk, or been stranded while in military service that appears to him to be appropriate for the purpose of protecting or preserving those remains, or on account of the difficulty of identifying that place. So it really is specifically the crash site. If there's a Spitfire crashed in a field, it's the actual crash site, not the whole field. So that's quite sensible. And for the purposes of the Act, a place is protected if it comprises the remains of or of a substantial part of, and I'm reading directly from the legislation here, or in the immediate vicinity of the place where the remains were left by the crash, sinking or stranding of that aircraft or vessel. So the power to designate any land as or as part of a controlled site should be exercisable in relation to Crown land as it is exercisable in relation to other land. So what that means is the Secretary of State can designate a protected place on Crown property, and he can also designate a protected place, if necessary and if appropriate, in my back garden or yours. So that's what that means. So that's all section 1, which is setting out the parameters and the definitions of what's involved, the words involved. Very important, the legal language. So section 2, subsection 1 of the Act is specific about offences, which is perhaps particularly interesting. And these are offences in relation to remains and prohibited operations. So it tells us that a person should be guilty of an offence, A, if he contravenes subsection 2 below, in relation to any remains of an aircraft or vessel which are comprised in a place which is part of a controlled site. So that means once a site is designated as controlled, you can't go near it. You cannot interfere with that site. And if believing or having reasonable grounds for suspecting that any place comprises any remains of an aircraft or vessel which has crashed, sunk or been stranded while in military service, he contravenes that subsection in relation to any remains by virtue of which that place is a protected place. So basically what it's saying is if you know full well a site is protected, or even if you suspect that there is a crashed aircraft or vessel or whatever there, you commit an offence if you go and interfere with that place. Then, if he knowingly takes part in or causes or permits any other person to take part in the carrying out of any excavation or diving or salvage operation which is prohibited by subsection 3 below. We'll come on to that in a minute. So if he knowingly uses or causes or permits any other person to use any equipment in connection with the carrying out of any such excavation or operation. So basically, if I was a landowner and there's a Spitfire, say, crashed on my land, and I said to, for argument's sake, my old mate Andy Long, I'm pretty sure, there's a missing pilot still in here, and if you want, you can come and dig it up. Well, Andy would get into trouble for doing the excavation, and I would get into trouble for causing and permitting it. So everybody's inched up, basically. Subsection 2 continues. A person contravenes this subsection in relation to any remains if he tampers with, damages, moves, removes or unearths the remains, if he enters any hatch or other opening of any of the remains which enclose any part of the interior of an aircraft or vessel, or if he causes or permits any other person to do anything falling within paragraph A or B above. So, that's pretty much about diving into ships, really, isn't it? Subsection 3 clearly defines when a diving or salvage operation is prohibited. A, if it is carried out at a controlled site for the purposes of investigating or recording details of any remains of an aircraft or vessel which are comprised in a place which is part of that site. Or B, if it is carried out for the purpose of doing something that constitutes or is likely to involve a contravention of subsection 2 above in relation to any remains of an aircraft and vessel which are comprised in a protected place or in a place which is part of such a site. C, in the case of an excavation, if it is carried out for the purpose of discovering whether any place in the United Kingdom or United Kingdom waters comprises any remains of an aircraft or vessel which has crashed, sunk or been stranded while in military service. So essentially you can't go and have a poke about just to find out whether there is a crash site there. No. Subsections 4, 5 and 6 provide statutory defences which in plain English are: 1, if the defendant can prove that what he did or caused or permitted was under and in accordance with a licence, that is a permission to recover issued by the Ministry of Defence. 2, that reasonable grounds existed for the person concerned not to believe that the area disturbed was a controlled site. So if you absolutely don't agree or didn't know, or you thought that you were digging in a completely different place, as in not the controlled site, then that's a defence. And that whatever was done was undertaken in the urgent interests of safety or health, or prevent or avoid serious damage to property. So I guess what we're talking about there is if there's some calamity with some live ordnance and something has to be done quickly to deal with it, to avoid great damage to property or even loss of life. So I suppose that's what we're talking about there. Subsection 7 states that a person who's guilty of an offence under this section shall be liable on summary conviction, so that's not a criminal conviction, to a fine not exceeding the statutory maximum. I'm not actually sure what the statutory maximum is at the moment, but that varies from time to time. On conviction on indictment, now that is a criminal matter, to a fine. So there's no imprisonment. It's basically all about fines. Summary conviction, at the time I wrote this, the statutory maximum was £5,000. It'll be a lot more than that now, because this is nearly 30 years old, certainly 25. In England and Wales, proceedings under the Protection of Military Remains Act can only be brought with the consent of the Director of Public Prosecutions, and in Northern Ireland by the same for that country. Scotland isn't mentioned at all in the Act, surprisingly, which is rather strange considering the number of vessels sunk around the Scottish coast. And I'm particularly thinking about Scapa Flow, where the German High Seas Fleet was scuttled in 1919, which I've dived a number of times, and indeed where HMS Royal Oak was torpedoed at anchor by U-47 just a few weeks into the war with great loss of life, which I've also written about. So that's a bit strange. Section 4 provides the Secretary of State with the power to grant licences authorising work at controlled sites under subsection 2. Such licences can be granted to a particular persons of a particular description, so that means they have to be identified, or say it could be an RAF recovery crew, so it's everybody in that particular unit, or to persons generally. The Secretary of State is also at liberty to impose any conditions in respect of any licence for any purpose connected with protecting or preserving any remains to which the licence relates. During the course of the licence, the Secretary of State can make any amendments necessary until such time as the licence is either revoked or expires, whichever is the soonest. Any amendments or revocation has to be notified to the licensee, either personally or published in such a manner as appropriate for bringing the matter to the attention of those concerned. And as a precaution against some of the situations which developed during the 1980s, previous videos in the series refer, subsection 5 creates further offences in respect of licensing if a person, whether for himself or another or for persons of any description, makes a statement or furnishes a document or information which he knows to be false in any material particular. So, or B, recklessly makes a statement or representation or furnishes a document or information which is false in a material particular. So what they're talking about there is sometimes to get the job done, licenses were applied for an aircraft that a pilot bailed out of, knowing full well that actually it isn't. It is the aircraft of a missing pilot, and the license has been issued on the grounds that it's legitimate, but when the recovery is taking place, human remains have been found, thereby embarrassing the MOD. So that is safeguarding for the Ministry of Defence against that circumstance. So the liabilities are on summary conviction, fine not exceeding the statutory maximum, and on conviction, on indictment, a fine. So it's all about fines. So this is a deterrent now for the MOD. I mean, this is serious stuff. You know, this is what they want. This is now given the weight of law and punishments to the regulations. So happy days for the authorities. And they issue a new note for guidance which explains the Protection of Military Remains Act, in which it said the remains of all aircraft which have crashed in military service, whether on land or at sea, are protected by the Protection of Military Remains Act 1986. So that means every single crash, whether fatal or otherwise, whether missing or not. It is an offence under that Act to tamper with, damage, move or unearth the remains unless the Secretary of State has issued a licence authorising these things to be done, and they are done in accordance with the conditions of the licence. So any group wishing to recover, and it's still the same today, any group wishing to recover an aircraft has to go through quite a paper chase with the landowner's permission, map references of where the aircraft is and so on and so forth. And it could be several people might have landowner's permission, several different groups, several different individuals, and in which case, and if it's not a dodgy one with missing pilot or anything else, live ordnance, the MOD issue everybody a licence. If, on the other hand, it is an aircraft of a missing pilot, then nobody's really going to get a licence, or they shouldn't, although recently there has been an exception to that, which we're going to talk about in detail in another video in the future, because I'm still waiting on the casualty section to supply me the information I requested about the whys and wherefore nots of that happening, because given the Protection of Military Remains Act and other matters, I cannot for the life of me understand how a licence has been issued in respect of a missing pilot a few years ago. So that'll be interesting for us to all pick over and investigate together. So yeah, you're not allowed to do a preliminary excavation. So if in my back garden somebody said, I think there was a hurricane crashed in your back garden, you know. Oh really, whereabouts? Well, in the top end where it's all a bit wild. Oh, okay, well, you've got a metal detector. Yeah, well, let's go and have a look, shall we? We're going to have a bit of a poke about and see what we've got. And if it looks like there's an aircraft wreck there, we can apply for a licence. No, you're not allowed to. You're not even allowed to do that. I did get unofficial go-ahead. I could do a magnetometer test on an aircraft that was in a lake in Norfolk by passing a boat over the top of what was believed to be the crash site, because that was seen as non-intrusive, which is fair enough. But you cannot go poking about on land. Simple. And this was all confirmed by the 1986 Notes for Guidance. And then human remains, you see, it says, you know, in many cases crews will have escaped from aircraft before they crash, but there is still a possibility of human remains being found. On receipt of an application to recover a crashed aircraft, the Ministry of Defence will try to determine if there is a possibility of human remains being found in the wreckage. If it is known or suspected that there might be, then a licence will not normally be issued. And normally is the interesting word there, isn't it? It's not saying we definitely won't issue a licence, it says normally. So what does normally mean? Well, that's going to be a question I'm going to put in due course to my old friend Clive Montelier, who's now the head of the casualty section at RAF Innsworth. Be interesting to see And that probably covers why a licence was issued in respect of a missing pilot. Something was abnormal about it, which allowed that licence to go through. So quite complicated stuff, and we're going to have a look at that in due course. So there we go. Personal property. Any items which are personal property of the pilot crew members, e.g. rings, watches, found amongst the wreckage, must be handed at once to the local police or forwarded to the Ministry of Defence. The Ministry of Defence cannot transfer title to personal property. Again, that's fair enough, isn't it? And then, of course, always concerned about publicity. Regarding adverse publicity, the notes tell us that the Ministry of Defence is concerned that neither the services or the department should become involved in any adverse publicity as the result of any recovery activities. Groups are requested to take all possible steps to prevent such an occurrence. In the event of human remains being recovered and you are approached by the press for information concerning the identity of the aircrew, you should ask the press to contact the Ministry of Defence. On no account, in italics, should groups divulge the possible identity of aircrew. And that's fair enough as well, because there have been instances where aircraft have been discovered in the firm belief it's a particular machine of a particular missing pilot, only to build up the hopes of a family to be crushed when the excavation takes place and it's a completely different pilot. So that's what that's getting at. And then it's all quite... it's all quite simple to understand, really. But you might wonder what powers the coroner has over this. And when I did this book, I spoke to Mr. Roger Davis, who was the coroner in what was then my home county, Hereford and Worcester. And he responded to me in detail, and he said, my observations are that firstly, it is clear from Section 4 that a licence has to be granted by the Secretary of State to any person or body of persons wishing to carry out an excavation of military aircraft remains. This must mean that no one, not even a member of a family of the deceased, nor a coroner on his own initiative, can authorise an excavation. So that was the coroner's interpretation of the law. Once an excavation has begun, licensed or otherwise, and a body is found, then the coroner has to be informed. The law is that whenever a body is found, the coroner in whose jurisdiction the body has been discovered has to be informed. It is then at this stage that a coroner has to decide what action to take. Exhumation hardly applies because the body has already come to light by the excavation itself. In any event, the coroner would have no power in the first place to order an excavation under the guise of it being an exhumation. The coroner can only order an exhumation in certain circumstances, and regarding those I will refer you to the book Jervis on Coroners, which states, a coroner may, by a warrant signed by him, order the exhumation of the body of a person buried within the area within which he has jurisdiction, when either of two conditions is satisfied. These conditions are, first, where it appears to the coroner that it is necessary for the body to be examined for the purpose of holding an inquest into the death or of carrying out any other coronial function in relation to the body or the death. And secondly, where it appears to the coroner to be necessary for the body to be examined for the purposes of any criminal proceedings, either instituted or contemplated in respect of the death in question, or any other death which has taken place in circumstances connected with the death in question. So clearly, the coroner cannot override the Protection of Military Remains Act and the Secretary of State. The coroner cannot grant me, for example, permission to go and recover a Spitfire pilot who might be crashed and I think is buried on my land. It cannot be so. Protection of Military Remains Act and the Secretary of State holds sway. So the coroner has no power to act independently of the Secretary of State or the legislation, cannot authorise a recovery, and there we are. And of equal importance, and if not more so, and this is really important and the crux of the argument really that's been ongoing and raging for over 40 years now. Relatives of the deceased likewise have no power to authorise any recovery. So although families may be totally in favour, and I know at least one that I'm in touch with, of a missing pilot would absolutely back us to the hilt to recover that individual if it was possible. But they have no authority in law. The fact that the families have supported this in law is meaningless. Absolutely makes no difference. So not even the families are being taken into account by this legislation. And that's really, I think, what upsets everybody. And the fact that these recoveries, we think, should be looked at on a case-by-case basis, because some are quite straightforward. Others are not, and others will be impractical. And the MOD might argue it opens the floodgates, but there are examples where the MOD have gone ahead and excavated sites, and in fact we're going to talk about some in the future, in future episodes. Not necessarily Battle of Britain crashes, but from later on, which shows that these things can be done. So. Another interesting is the Secretary of State is not obliged to task the Royal Air Force with the recovery of a missing airman, so could actually license a private individual or group. So it's quite wide-ranging, isn't it? And a lot of it is policy that's being made up as everybody goes along with the Act in mind and as an evolving thing, in my experience. So that's the Protection Military Remains Act. It's a bit complicated, but it isn't when you actually sit and read it. It basically means you can't do anything. However, people have. And what's happened to them? That's interesting, isn't it? Interesting to know. It's interesting as well that people feel so passionately about all this that they will go ahead and take the law into their own hands and suffer the consequences that come their way consequently. Whether that's an admirable thing or otherwise, it is up for you to decide. And many believe, as in fact there have been comments on threads beneath these videos, that there can never be anything wrong with recovering a warrior for a decent burial, a respectful military funeral, or indeed recovering any missing person for a respectful burial. So it's one of these things that polarises opinion and is emotive and vexing and all of those things. So going forward, now we've got the background, we've got the chronology leading up to the Protection Military Remains Act. In the next videos, we're going to look at the recoveries that have taken place since 1986, because there have been one or two developments. Then we're going to get Group Captain Montelier in to give the MOD's view on all of this. It's not a witch hunt. Can't blame people for things that happened 40, 20, 10, 20, 30, 40 years ago when they weren't in post. It's not a witch hunt at all, but I think it's fair to give the MOD a chance to explain its position. And also we'll probably be speaking to Steve Vizard, my old friend who's been involved in this since Pontius was a missing pilot, or so it probably seems, who will no doubt have a bipolar opposite view. So we've got some interesting stuff coming ahead. It's all free to watch. Please subscribe. Let's grow our community. Join the conversation. Any comments, good or bad, any observations you might have, any opinions, please put them in the discussion below. I'll try and reply to everybody. Or if he doesn't reply, at least put a like or a lovely comment. And any ideas you might have, let me know. You can contact me through my website, dilipsarkerauthor.com, and we'll speak again soon. So thanks for listening. I hope you didn't find it too dull and dreary looking at legislation, but it's important. And now we've done that, we can look at maybe some much more interesting stuff. So thanks for watching and listening, and I'll see you soon.